Hello, my name is Kimberly Pachowiak, and I'm the Protective Order Resource Attorney for the Texas Office of Court Administration. Today we're going to talk about protective orders and the importance of TCIC reporting, specifically the big picture and also focusing a little bit on the criminal justice information users. In other words, those people in the law enforcement agencies who are responsible for actually doing the data entry of the protective orders into the TCIC system. Prior to coming to OCA, I was a prosecutor in San Antonio, Texas, Bexar County, for approximately 20 years doing family violence prosecution. And during that time, I found that my sometimes crazy sense of humor certainly got me through my day and helped me want to get up and do my job every day, because it certainly is not an easy topic to have to deal with on a regular basis. So, some of that sense of humor tends to leak into my presentations. So I just want to warn everybody, being the lawyer that I am, this is my disclaimer. Usually sarcasm is the biggest issue. But I wanted to let everyone know that just because I do have a sense of humor and I choose to let it help me get through everything that I need to get done, does not mean I do not care about this topic and want to share how important it is and how near and dear it is to my heart, which is why I'm here to talk to you today. Because if we couldn't laugh, we would all go insane. And I'm sure that my job and my prior job is not the only one that this statement would be appropriate. Which is why I usually include something like this. What sort of flowers say, "I promise to obey the protective order"? And while we can laugh at this because it just seems totally ridiculous, unfortunately, it is a pretty clear example of what often happens in protective order situations. Many times it's much, much more serious than this, but even at the very least, sometimes even something this minor can be the basis for the violation of a protective order, and certainly can be the basis for batterers who want to either stalk or otherwise harass their victims. And so it's just something to kind of keep in mind, that although this is kind of funny, it certainly comes down to that there is a definite serious side to this. So when I say domestic violence, this is what many people think about. Remember this show? They are still making it. It's 25 years old. And unfortunately, many folks who don't have any experience with dealing with law enforcement situations or domestic violence situations and how that comes to the attention of law enforcement, this is kind of what they think about domestic violence. And oftentimes, you're seeing people at their very worst. Oftentimes, you can't really tell who the problem is. You can't really tell what the situation has been and what's been going on. It's just a really ugly situation, that snapshot in time. And sometimes both parties wind up getting arrested. And so that's what people tend to think about. However, it's usually more like this.
Where's dinner?
Well, I thought you'd be home a couple of hours ago, and I put everything away.
What is this? Pizza?
You had just called me. I would have known what.
Dinner ready is pizza.
Honey, please don't be so loud. Please don't. Let go of me!
Get in the kitchen!
No!
Do you want to see what hurts? That's what hurts! That's what hurts!
Oh, please. Please.
For information, call 1-800-END-ABUSE.
And that is a little bit more accurate depiction of what goes on behind closed doors. So to begin, just a quick glance about what we're going to be discussing in this webinar. First of all, we're going to talk about what is NCIC, TCIC, and NICS. This will just be a quick overview. I know a good portion of this audience is already going to know that. I get it. But it's always a good idea just to have a quick refresher. And I always try to remind myself that not everybody knows, and certainly other participants in this process are not aware of what all of those things are. We're going to talk also about the types of protective orders that should be getting entered. And then we're going to go into why do we care about protective orders and their entry into TCIC to begin with. And that's going to basically be covering a little bit about domestic violence, some of the dynamics, the prevalence of how it is in Texas and across the country, and some of the barriers that people have in reporting and dealing with domestic violence, because those are good things to keep in mind as we are dealing with the mundane tasks that we have to deal with every day that involves the documentation and the paperwork and all of that. We're also going to talk about how not getting these entered into the system properly can affect funding, and also certainly how it can affect research. Then we're going to go into the process a little bit more. Who participates in this particular process? We did a study that we talked to a bunch of the different participants at different points in the process. And this discussion is going to talk about the things we found out, who participates and how can we improve it. What are some of the obstacles that people were running across, and then identifying some of the really good best practices that we saw across the state and that we want to share with everyone else. So first of all, what is NICS? NICS stands for the National Instant Criminal Background Check System, and it was created as part of the Brady Act in 1993 for a computerized process to provide information on whether or not someone is eligible to receive or possess or purchase a firearm. It looks at criminal, mental health, protective order, and other types of records. Criminal records, obviously felonies, also misdemeanor crimes of domestic violence, mental health adjudications and commitments, and then protective orders, different types of protective orders. And often, not always, but FBI can make follow-up requests to the police, the prosecutors, or the courts for additional information so that they can determine whether or not someone is really prohibited from buying a firearm. Because if they have some holes in that information, it really is important for them to fill in those gaps as soon as possible. So sometimes they will actually contact the different agencies and courts to find out what they need to find out. So NICS was created in 1993, but in 2007 this happened. It was the shooting at Virginia Tech, in which there were 32 people killed and 17 were wounded. And obviously, the responsibility for this certainly lies with the person who committed this horrible crime. But it highlighted the fact that there was a big gap in some of the information that was available to NICS. And so the federal government passed the NICS Improvement Amendments Act of 2009, and it addressed specifically mental health adjudications and certain commitments and other prohibiting factors. Because the Virginia Tech shooter was able to actually purchase a firearm from a licensed seller, going through the background checks, but his particular mental health adjudication was different in that it was an order into outpatient treatment instead of inpatient treatment. And so that did not trigger the information to let everyone know that he was not eligible to have a firearm, or should not have been. So they were unable to deny him the transfer of the firearms that were ultimately used in the shooting. So another what has to do with the alphabet soup, all the different acronyms for the systems that are involved in this process. First of all, and I know this is just review for most of you guys, is the Texas Crime Information Center, which is accessed via TLETs and provides responses within 12 seconds on people, whether or not they have a warrant, or there's missing persons or stolen property, or if there's a protective order. And the other great thing about it is it links to the national version of this, the NCIC, so they also know about if this is someone from out of state who has a protective order or is wanted, that they can find that out if that information has been entered into the system. So then the other one is the Interstate Identification Index, which is the federal criminal history database. Then ultimately, all of this feeds into the National Instant Criminal Background Check System that checks all of those records and also the NICS index to determine if people are qualified to receive a firearm under the law. Now, moving on to a quick review of the different types of protective orders in Texas that should be getting entered into the system. First type of order is the 31 to 91 day Magistrate's Order of Emergency Protection provided for in the Code of Criminal Procedure. The next one is a 20-day temporary ex parte order under the Family Code. And then finally, the permanent protective order that can be done for sexual assault, family violence, domestic violence, dating violence, stalking, trafficking, any of those types of offenses. Now, the criminal version, arrest is required, and that's going to be the magistrate's order of emergency protection. And it can be for family violence, sexual assault, or stalking. Has to be issued before the abuser is released on bond. So they're arrested for the offense. The order is based upon the information in that offense and must happen before they are released on bond. 31 to 91 days, as we talked about. And it can be mandatory if a deadly weapon was used or if there was serious bodily injury. Now, the civil version, there is no arrest required. It is the temporary ex parte protective order is the first one. It is basically immediate relief from the judge based upon an application to the court. It is up to 20 days. And basically, when that order is issued, there's also a hearing set to happen within that 20-day period for there to be a decision made upon a permanent protective order. So, in the permanent protective order, the abuser is notified to appear. And it is usually going to be issued after a hearing or an agreement. It can happen both ways. And it's usually 2 years, but it can be longer if there is serious bodily injury. And if the court finds that there are 2 prior protective orders that were violated by the abuser. So after the order is issued, what happens next? The order shall be sent to either the chief of police or to the sheriff, it depends on where the victim resides. And a magistrate shall order the police to make good faith effort to notify the victim, and the clerk shall send a copy to the victim. Now, if the order prohibits that person from also going to school or a child care facility, then they shall send a copy to that school or the child care facility. Other notifications that should happen, DPS should be notified. If the order suspends a concealed handgun license, which actually is required for a magistrate's order of emergency protection, the defendant has to be notified as well, and usually that's going to happen in person. If it's a magistrate's order, obviously it will be served. If it's not a magistrate's order, if it's a regular protective order. But if it's done and for a magistrate's order of emergency protection, it can be the magistrate or their designee, which is often going to be the bailiff or the law enforcement officer, or maybe the clerk. And also it can be done electronically. That was a change that was made last session. But the magistrate would have to make a separate record of service in written or electronic form to show that it was actually served. Now, why do we care so much about protective orders and whether or not they're entered into TCIC? Protective orders that cannot be verified will often not be enforced. And so you have your 2 main goals, safety and accountability. And if you can't enforce a protective order, then it is truly just a piece of paper. And there goes your safety and accountability goals right out the window. Now, when it comes to safety, we're talking safety of victims. First of all, they are unprotected and suffer further abuse if a protective order cannot be enforced. Sometimes a copy of a protective order may actually be taken or destroyed by the abuser. It's not at all uncommon if that abuser realizes that that victim is trying to get out, that they start destroying important items such as any type of court papers, financial records, birth certificates for the kids, anything that's going to help that victim maybe get kids re-enrolled in another school, any of that stuff. So they start destroying that type of paperwork. Sometimes they may just not have yet received a copy from the issuing court because there usually is going to be a lag time of a couple of days, at least a few hours, depending on the type of court and how they're doing it. And so sometimes they just haven't even received it. And it's that first few hours or a couple of days after a protective order is issued that can be really, really most dangerous. Now, law enforcement officers, obviously, if you're a law enforcement officer, you certainly want to know that if someone you just pulled over for a traffic violation is potentially dangerous, and a protective order is a pretty good indication that, yeah, they are capable of some dangerous behaviors. It's also good to know for that law enforcement officer is that not only is there a protective order, but maybe they are in the neighborhood of where they're not supposed to be going to violate that protective order. And certainly the safety of the community. We all know domestic violence does not stay at home. It goes to work, it goes to school, it goes to the grocery store. My husband is a police officer for one of the largest school district police departments in Texas. And the Friday before Christmas break last year, he was home for lunch. I get to work from home some days, so I was home for lunch. And we listened to several incidents that came over the radio where officers were being called to the scene because a parent was trying to come pick up kids in violation of protective orders because it was the last day before Christmas break was getting ready to happen. So it definitely happens. And so even if that's not particularly our kids are going to school with those kids. So it's always really important to make sure that officers can take action based upon these protective orders. Accountability. Anyone who knows or has children understands that if a violation goes unpunished, just like if bad behavior in your children goes unpunished, that behavior tends to get worse and tends to repeat itself. And also, it will increase the opportunity for an offender to retain or procure firearms. So that's always the danger as well. So not only does bad behavior get worse, then they are able to kind of get some of the tools that actually makes their bad behavior even that much more worse and much more dangerous. But the question always comes up, do protective orders actually provide safety? I mean, we've all heard, well, a protective order is just a piece of paper. And yes, last time I checked, protective orders not bulletproof. They are not made of Kevlar. However, it's the enforceability that makes all the difference. At the Carsey Institute at the University of New Hampshire a few years ago, they actually did a study on this, and this is the link online to the report if you would like to see it. What they figured out was for about half of the victims, a protective order stopped the violence. Now, that is not to say that it was just the protective order necessarily, but in cases where there was a protective order, the violence stopped in half of the cases. It might have also been because if someone is getting a protective order, they're probably doing other things to try and keep themselves safer, doing safety planning, pursuing, change of address, I mean, different types of things. And then for the other half, the violence was significantly reduced, even though it didn't stop. But as usual, there are some caveats. The big weakness is enforcement, especially in rural areas, although I know that enforcement is an issue pretty much in all areas to a certain degree. Obviously, if there's fewer resources, if your closest shelter or victim services location is 3 counties away, that's going to make it harder. Local politics is always an issue. It seems like there's usually somebody in power in an area, potentially rural, that either knows someone or is affiliated with someone who is a troublemaker, and that troublemaker tends to not be held as accountable sometimes because of who they may know in the system or be related to in the system. And last, and this one certainly is not just in rural areas, but sometimes law enforcement has either difficulties or reluctance in determining whether or not there is a predominant aggressor in the situation. Sometimes it's easier just to arrest everybody and let the court sort it out, which we all know, the prosecutors in the court, if a determination is not made usually at the scene, it's really, really tough to make that determination later on by someone else who was not at the scene. And so that's why it's so important for law enforcement to make those determinations and to ask those questions to try and get that done. Because we've all kind of seen this situation. And then next thing you know, everybody's getting arrested, even though obviously there's someone here who's a little bit more dangerous than the other one.
Looks like Elliot's gone pinned.
So, an important thing for everyone to kind of keep in mind when it comes to family violence is that no relationship goes from happy, healthy, and functional to murder suicide overnight. There is always a pattern of abuse. Whether or not anyone else knows about that pattern is one thing. Whether or not authorities are contacted or whether or not someone seeks a protective order, the police are called, but there is always a pattern of abuse. And when you speak to victims of domestic violence who've been going through it for a while, they will usually talk about that things went on long, long, long before they ever told anyone else. And it usually starts very small. While thankfully not every domestic violence incident winds up as murder, suicide, or murder, almost every, I would say every murder, suicide involving domestic violence always started with something small, way, way small. Maybe a long time ago, maybe months ago, maybe years ago, but then it tends to escalate over time. So there's a couple of different patterns. The first one is the fact that there are always actions, physical, sexual, emotional, economic, and psychological, that are used to gain or maintain power over an intimate partner. And these first three, these first two, the physical and sexual, those are things that potentially can be addressed by the civil and criminal justice system. However, it's the last three, the emotional, economic, and psychological abuse, that tends to really hold that victim in that situation a lot longer, in spite of the physical and sexual abuse that's going on. And so there's something called the power and control wheel, which is a very handy tool that has been around for many, many years, probably going on to about 4 decades now. It was kind of first looked at and put into practice in Minnesota, and it's based upon conversations with victims of domestic violence. And what they found based upon these conversations, and we're talking hundreds and hundreds of people that they spoke to, that there was a very discernible pattern, that there were certain things that almost always, not always, but almost always, were present in this power and control relationship. And that is using intimidation, emotional abuse, isolation, the concept of minimizing, denying, and blaming. And lots of times it's not just the batterer who's doing that, but also sometimes the victim is minimizing and denying what's going on. Children, using children as kind of a weapon, making victims feel guilty for some reason, using them to relay messages if that couple is no longer together, threatening to take children away, using male privilege, using economic abuse, and preventing her from getting a job. Maybe she doesn't know any information about any of the family finances, and always, coercion and threats. And usually there's different types of coercion and threats, usually threats of violence, but not always. Sometimes it's threatening that to make her do illegal things, threatening to report to welfare, threatening to commit suicide. All of those things all have a way of making that victim do what they want them to do. And generally, batterers only use as much force as necessary. And then once that amount of force is not doing the job anymore, then that's when they start ramping it up. Another pattern that tends to emerge is the concept of continuum of violence. And as we discussed earlier, bad behavior tends to get repeated and it tends to get worse. Well, it's the same with this type of pattern. When it comes to the verbal and emotional part of that, it will often start as name calling and maybe escalate to yelling. Now, I will tell you, and I'm sure this is not a surprise, victims of domestic violence will put up with a lot of things that happen behind closed doors for a long time. And this is certainly one of the big ones. And it may tend to escalate, but as long as it remains behind closed doors, then oftentimes they're willing to put up with a lot of that stuff in order to make sure that there's a roof over their children's head and that kind of stuff. However, once it tends to escalate into public humiliation, then sometimes that is a clue for victims and a red flag for victims that it's maybe time to do something about it. Because what that tends to tell victims of domestic violence is that this person, the abuser, really doesn't care what other people think about him, which is kind of different, especially at the beginning, because usually batterers go out of their way to make sure that the rest of the world thinks they're nice and reasonable and charming and all of that. However, once it gets to the point where they don't care about that, then for them, the situation is getting more dangerous, and they are correct in that. The next type of this is physical violence. And again, tends to escalate. Might start small, might start as a push, which in Texas would be a true Class C level offense. No injury, then no jail time. But it certainly is something that is offensive and scary. Might escalate to punching and may stay there for a while, or might just happen once. Again, as much force as that abuser feels necessary to get the job done, and can escalate up to kill. And then finally, sexual. It may start with objectification, which, you know, society tends to think of as relatively harmless as a whole, certainly not everybody, but in general, objectification is an obnoxious behavior that most people are think is harmless, but then it tends to escalate. And I had many cases when I was prosecuting, especially when I was prosecuting the low-level misdemeanor cases, where there would be visitation with the children, and so abuser would show up at the house to drop off kids or pick up kids, and when if the kids weren't right around right then, they used that opportunity to push that victim up against the wall and begin groping. And it was to send that message that we may not still be together, but I can still do whatever I want to you. And so when those things are happening, again, that's an escalation of the sexual type of contact, and then all the way up to forced sex. Lethality is another part of this equation. We're looking at the pattern of what has happened in the past to see, okay, what might be happening in the future. And this is certainly important when it comes to anyone that has anything to do with intervention and prevention in domestic violence cases. And certainly for judges as well, who are making determinations regarding, do I need to do a protective order here? What kind of indicators do I have that show me that this is a situation that is getting more dangerous? And there are a couple of different risk factors, but a couple of the biggies. First is prior family violence. In 72% of domestic violence homicides in this country, there was prior reported family violence that occurred. And even more startling would be 76% of female domestic violence homicide victims were actually stalked by the intimate partner that ultimately killed them within a year. So anytime we are seeing that, it is certainly something that we need to keep an eye on and seeing what's going on. Other important factors that can help forecast whether or not this is a dangerous situation that may lead to a domestic violence homicide include threats, increases the chances by almost 15 times. The use or exhibition of a weapon during the incident increases it by up to 20 times. Strangulation, up to 9 times. Forced sex, almost 8 times. And extreme jealousy, 9 times. So these are all things that officers should be encouraged to include in their police reports about prior incidents, things that have happened in the past, because they are all things that can help give a better picture about what may be to come. Domestic violence in Texas. There are several different types of statistical measures for this, but just really quickly, some of the basic information. 32% of all Texans have experienced domestic violence. This was a study that was done in 2011 at UT. And it asked specifically, have you experienced it? Not did you commit domestic violence, or were you a victim of domestic violence, or were you defending yourself in a domestic violence situation? Just have you experienced it? That's 32% of all Texans, so about 1 in 3. If you're female, 38% of females and 27% of males. In 2013, there were 119 women killed by intimate partners, along with 17 bystanders, and 5 of those bystanders were the children of the women that were killed. And in 2013, also according to DPS, there were over 185,000 reported domestic violence incidents. Now let's keep in mind that is reported. 97% of them were assaults, and of those assaults, 74% were deemed to be simple assaults. And those are going to be the type of assaults that would be a Class C level type of misdemeanor here in Texas, little to no injury, which is usually the kind of the ground floor type of incidents that begin a cycle of domestic violence. And when it comes to injuries, pretty much the same kind of picture. No injury, 42% of those assaults. Minor injury, 53% of those assaults. And then major injuries, which would be felony level injuries, which would be your serious bodily injury cases, only about 5%. Something to keep in mind about injuries, though, is that experienced batterers do know how to hit without leaving any immediate or subsequent visible injuries. And so, oftentimes in police reports, it might say miter redness, a little bit of a scratch, or something like that. However, many batterers they know to hit in the soft tissue areas or sometimes in the head, so that you don't have any obvious injuries, especially up front. And what looks minor can often change over the next few days. For example, what can look like this today, obviously this is a bite mark, and yes, you can certainly see it. It is certainly an injury. It can look like this tomorrow. Also, what might look like a regular minor grabbing incident, which is usually a relatively common Class C misdemeanor type of injury, might look like this tomorrow. So, which is why we've got to make our misdemeanors count. Waiting until we prosecute the case when it becomes a murder is often too late, always too late. We must realize that true success is not in prosecuting a murderer, but it is preventing the murder in the first place. And the more we focus on those low level injuries and those types of cases, the more chance we're going to have of being able to reduce domestic violence homicide. So, when it comes to reporting, we certainly have to talk about how much actually gets reported. Actually, unreported by victims about 15% of the time. Reported by a third party, maybe about 8% of the time, leaving us with a whopping 76.9% of cases that go unreported. And there's all kind of reasons for this. Some of this we've already talked about. We've talked about the level of injury. We've talked about all of the mental and emotional things and all the power and control aspect of this that might or often do stop victims from reporting incidents. Other reasons that it's too minor. They feel it's too minor. They feel that they would be too embarrassed for anybody to know. That goes along with it. Many victims think that this is their fault in some way. Obviously, fear of reprisal, and often that the police cannot do anything, which is sometimes many victims think that unless you're bleeding on the floor, it really doesn't count as a crime, which is not at all uncommon, and a lot of society unfortunately seems to think that as well. And many just think they're not going to be believed. But another aspect of this, or one of the other aspects of this, is there are a lot of reasons and barriers that are kind of put up by the systems themselves. Example, in the criminal justice system, we already know that few victims report. And that's because there's complicated statutes that often do not reflect the reality of family violence. So then that will lead to fewer arrests and fewer reports that get sent to the prosecutor's offices. So then ultimately there are fewer charges filed. Of those charges that get filed and actually go to court, often there are fact finders who do not understand the dynamics or choose not to believe them, and so don't convict on the cases that are presented. So then you wind up with fewer convictions. Victims certainly then get the feeling that they are not safe and that the offenders are not going to be held accountable, so that's why they don't report. In the civil justice system, it is quite similar. Again, victims do not trust the system. They fear disbelief. Again, a lot of this applies also on the criminal side. Often there is a lack of objective evidence, or they don't present well. The victims don't present well in court. And while it would be really nice if we had video evidence, such as that in an elevator in a casino in Atlantic City last year. Certainly, that is not the case, and most batterers are smart enough to do it with no witnesses. So then, protective orders may get denied, or batterers may get custody or unsupervised visitation because there's not enough evidence. And unfortunately, batterers that seek custody often get custody, even though there is evidence to the abuse. Then, victims may respond in ways that they feel is going to protect themselves and their children that may not be in compliance with court orders. So then they understand that they don't really have the legal protection, or they understand that they're going to be punished for not following court orders. So again, they don't feel safe, and offenders are not held accountable. So they're not going to access the system. And of course, these barriers and the barriers from the power and control wheel that we talked about are on top of other barriers that we know exist, such as religious, cultural, those types of things. So all of these work together to make us remember that, victims may have a whole lot of really good reasons to not want to participate in prosecutions or participate in the justice system. And so it's up to us to kind of help make that easier. So moving on, why do we care about protective orders and TCIC when it comes to federal funding? Well, federal funding is often predicated on certain conditions that exist in the states or the people who receive the funding. And the NICS system requires that states report all of the Brady disqualifiers, and those are some of the things we talked about earlier. The felony convictions, misdemeanor convictions of domestic violence, mental health commitments, and protective orders. Now, if we cannot show that we are getting all of these entered properly, it can actually hamper our ability or our eligibility to get funding, and we're always looking for more funding to try and help more people and do our jobs better. Um, so if in compliance, a state may be eligible to receive a waiver of the 10% cash match that's required in certain federal grants. And if you've ever written a grant, and if so, I'm sorry, but you understand that being able to have that waiver is a really good thing to have. It's nice not to have to worry about their cash match. And also, if we're not in compliance, there are burn justice assistance grants, which fund projects at the state and local level that have to do with criminal justice. If we are not in compliance, then we may have a reduction in what's available to the state. And just an example, in 2013, the Office of the Governor received over $21 million from burn grant funds. And so, again, it's really important for us to try and make sure that we are getting everything that we possibly can and all the type of funding that will help us do what we need to do. So, and then finally, research. Research the concept of garbage in, garbage out. If we don't have good information that's going into the databases, it's really hard to extract kind of the cumulative information or the overall picture of what is going on. And if we don't have a really good picture of what's going on, it makes it much, much harder to identify the areas of need as far as sending resources, not just money resources, but also people resources, education, training, any type of facilitation when it comes to community organizing or anything like that. It is certainly a good idea to know what that need is and where we can improve. So, knowing that, based upon a couple of years of going around and doing some training and talking to various people about protective orders, it kind of became obvious that not all protective orders are making it into the system. And so we sought funding from the DOJ so that we could look at the reporting process from start to finish. Who was involved? What were the processes? What were some of the procedures, the forms, from the application stage all the way to when it gets entered into the system, and every stage in between, so that we could try to increase the reporting of the orders. So we met with law enforcement, judicial and court clerk training organizations, other organizations that have anything to do with this, criminal justice users, DPS. We also conducted case studies in 8 different jurisdictions across the state, and we tried to do rural, suburban, urban, and also geographically, we tried to go all over the place. We went down on the coast, we were up in the Panhandle, we did East Texas, we did South Texas. We also did a statewide survey, and those of you who may have participated, thank you so much. We certainly appreciated getting the information. We actually had about 850 completed surveys, which I was really surprised, and we got a lot of good information. And so we also created a task force to help develop recommendations based upon all the information that we gleaned from these discussions. And so, what came out of that, one of the things is to develop training to improve the reporting rates. And that's part of these trainings here. I go around the state, do lots of training for various organizations. And we already have 3 webinars that are on the website. And this one is going to be going on here shortly. And we're hopefully going to do one more pretty soon. So then that way we can make this training available to let folks know kind of what are some of the things that they can be doing to increase their chances of making sure protective orders are getting entered into the system properly. And just as an example, we have 254 counties, as we know. The counties in white are the only counties that we did not hear from at least one person in that county about the process in their jurisdiction. And that's only about 12 counties, if I remember correctly. And so everybody else, we at least heard from somebody, and in many counties, several somebodies with several different roles in the process. So I was very pleased that we got such good feedback. So, that being said, how many participants are in this process? How many cooks are in this particular kitchen? Who has the information? Who has the paperwork or does the documentation? Or maybe both. Maybe this person has something to do with both aspects of that. And let me tell you, it's quite a few people. When it comes to magistrate's orders of emergency protection, and remember those are the ones that are issued by a magistrate at the time of arrest, but before release from custody. We have the victim. We have an officer, and because there is an arrest, we're going to always have an officer in these. We might have an advocate. Some jurisdictions have an advocate or an attorney that might have some role in gathering their information or contacting victims, or both. And then it gets sent to the court clerk. Whoops. Then it goes to the judge, the magistrate. Then it goes back to that court clerk. Then it goes to the district or county clerk in some jurisdictions. Some of the jurisdictions want their district or county clerk's offices or the offices want to have that, so they have a record of it as well. And then it will go to the police department. And sometimes in the police department, just like in any of these other areas, but often in the police department, it may go 4 or 5 different places within that department before it actually lands on the desk of the person who is going to be doing the data entry. And then to the data entry person. And then for protective orders, it is potentially even worse as far as the number of people involved. It goes from the victim, sometimes to an officer, sometimes not, because there's no requirement that in order to get a protective order, there has to be a police report. There might be an advocate or an attorney. Then it will usually go to the county or district clerk's office, then to the clerk in the particular court, then to the judge, then back to that clerk in the court, then back to the county clerk's office, then over to the law enforcement, and again may go 3 or 4 or 5 different places within that agency before it lands on the data entry clerk's desk. So that's a lot of different ways that this can go crossways. And speaking of a lot of different ways, we have such a decentralized court and law enforcement system in Texas. As we talked about, we have 254 counties, 458 district courts, 510 county level courts, 817 justice courts, and 926 municipal courts. And in those courts, there's about 1,288 judges. So, again, a whole lot of different ways this can go crossways. And then of course, law enforcement agencies. And everybody does it differently, or most people do, at least to a certain degree. One of the other big obstacles is that they may not even be getting data sheets, TCIC data entry sheets, accompanying the protective orders when the data entry person receives it. If they do, a lot of times they're incomplete. Uh, Many times participants are not even aware of the roles of the other people in the process. So it makes it really hard to understand what they need from you and what you may need from them. And they don't know what to give you. Other common problems: lack of regular communication, not only between different agencies, but within agencies. Lack of standard forms and orders. And like we said, a lot of folks, they do it their own way. There's a lot of suggested forms and orders out there, but everybody seems to tweak it depending on what their particular needs are. Confirmation procedure that the order was actually received by law enforcement. Sometimes there is one, sometimes there is not. I've been encouraging courts and clerks' offices to have a process and a way to have that confirmed with an actual live person at the law enforcement agency, so that it is initialed and sent back in some kind of a documented form so that they know that it was received. If there is no such thing in your jurisdiction and you are part of the law enforcement agency, if you want to have something that you send back, I would highly encourage that as well. Sometimes there's a lack of personnel to assist the victim or petitioner with the application. Some jurisdictions have lots of people that can help. Other jurisdictions have nobody that can help. And so sometimes that form just gets sent or given directly to the victim, and they have to fill it out. Anybody who's seen this form, that even if you're in this system and work with it a lot, it's not an easy form to fill out. So there's a lot of things that may wind up on that form that are inaccurate or inappropriate or maybe not even part of what was actually ordered by the court. Insufficient police investigation, documentation, and enforcement. We've all seen that. It certainly is not majority of the time, but it's enough that it's something we all need to be concerned with. Typographical errors during data entry. Many jurisdictions have a process in place. Sometimes it's somebody else on that same shift who comes and looks at what someone just entered into the TCI system to make sure it's accurate. Sometimes someone on the next shift checks it. Either way, I would suggest you have some kind of a cross-reference way to do that. When it comes to law enforcement, top challenges are identified: again, missing forms, incomplete data, or sometimes conflicting information. And if you are a person who's responsible for the entry of the protective order, this is nothing new to you. You will have a protective order that says one thing, but your TCIC data entry form says something else, and then you are having to make decisions. And you can't make really decisions. You can certainly make changes based upon new information if you need to, but never to the order, as you know. I would certainly encourage you to let the court know of this new information that you may have found while you're running your systems checks, and then that way they can make changes on the order if necessary. Private attorneys sometimes fail to send the order, which I don't understand, but I do believe in some jurisdictions, what I have found out is that the attorneys often show up at the law enforcement agency with the order, which should never be the way it goes. It needs to go to the court clerk's office, then they do what they need to do with it, and then the clerk's office sends it, the county district clerk's office sends it to law enforcement. Confusion regarding out-of-state orders, validation or modification. Obviously, this has so much to do with full faith and credit, and so that's a whole other separate issue, but it certainly is something that was mentioned. Delaying the receipt of protective orders from the clerk's office, especially if they were sending it by regular postal mail, snail mail. What we are encouraging and have been encouraging everybody to do is that if they have an electronic means to send it, please do it. Obviously, a safe and secure means to send any of your communications. If you can do it by email or by fax, however is easier, but it's certainly a more instantaneous way to get it where it needs to go. But we've had some jurisdictions, some law enforcement agencies tell us that what they received was from clerks' offices, a big stack, and some of those orders were 2 weeks old, and some of them were from yesterday. So anyway, they can get it much quicker. Lack of timely notification when a protective order is extended or modified. One of the things we heard from talking to law enforcement was they may not even know if something's been extended or modified for some reason, and then they don't get notification, so they can't make the change in the system. And then who is entering the order if we cannot determine the address of the complainant. Obviously, it needs to be where the complainant lives, that law enforcement agency where that person lives. However, you may not always know where that person is currently living. So one of the changes we're looking at making, that has already passed both the House and the Senate, so hopefully it's going to be happening this session, is we don't know the current address, then look at the last known address, and then that agency is the one who enters it. And we really don't care who enters it as long as it gets entered. It's just we don't want that back and forth delay because we're trying to figure that out. Some of the top recommendations from law enforcement agencies, our data entry folks that we spoke to want more training on the Brady indicator so that it's getting done. Many agencies are not even doing it because they're not exactly sure how it needs to be done. Deadline for clerks to forward to the agency. There is no such deadline currently in the law. However, as part of that same bill that I talked about with the sending it by mail, we are also asking for there to be a deadline to be instituted, and actually a pretty quick deadline, the end of the following business day. Obviously, that will be maybe longer if they're still hunting down the basic mandatory information that needs to be entered. But having that deadline was an important aspect that we wanted to include in that legislation. And also requiring the data sheet to be completed and forwarded to the entering agency, certainly upon renewal of the order. And having the form accompany the order at the time of filing. The sooner in the process that that form is completed, the better chance we have of making sure to catch any changes in the information, to make sure all the information is there. That way everybody who it gets sent to can verify and check it. So other big picture recommendations, mandatory uniform forms statewide was certainly something everybody, regardless of their role, wanted, which is a very good idea. Now it's just going to be a matter of trying to figure out what those forms need to look like. Training of all participants, as expected. Excuse me. Most agencies or most people that we spoke to, they were really big on, no, we're doing it fine, but those people over there are not, and they really, really need training. But we also had a lot of folks who are saying, I want more training. I want to know more about the process. I want to know more what I can do and what other people do so that I can make sure I'm doing what I need to be doing. And so when we asked what should that training include, almost everybody across the board talked about they wanted to include dynamics of domestic violence, which is why we just had a little bit about that. The types of protective orders and the importance of the information gathering process and everybody's responsibility to make sure that that is happening, from the judge to the clerks to the law enforcement, whether or not you're the responding officer or you're the data clerk or you're an advocate. Everybody has an important responsibility there. Legislative changes that have been recommended and have so far passed both houses of the legislature at this moment. Shortening the deadlines for clerks to send the order to law enforcement. We talked about that. Shortening the deadline for law enforcement to get it entered. I know that most law enforcement agencies do it pretty quickly. Others do not. And so for some reason that deadline was 10 days here in Texas, which the more we looked into it, did not make sense because the federal deadline is 3 days. So what we're looking to do is make that 3 days. And mandating the entry of magistrates' orders of emergency protection. Those are currently not mandated, which is crazy because that's the great majority of protective orders in Texas. However, this bill will also include that actually is mandated, required to be entered into the TCIC system. Clarifying which agency should enter, which we just talked about if you don't know the current address, and looking at the internal procedures to reduce the number of hands that actually touch it. So if you've got a lot of different stops in your agency, look what you can do to streamline that process and see if it can come directly to you as opposed to going to 3 or 4 different people in the chain. Other recommendations, using available forms that are there. TMCEC, the Texas Municipal Courts Education Center, has a lot of good ones in their form book. They have examples of the magistrate's order. They have other orders and also the TCIC data entry form. Finding out what the full process in your agency is another good recommendation. Not just what it is in your agency, but for your whole jurisdiction. That way you can kind of plot its path and see where things can be adjusted. Last but not least, talking to the other participants or agencies involved in the process. I'm sure I've mentioned this already. It cannot be overstated. The more people can get together and just talk about the process, do it. Find out about other agencies' meetings that are involved in this process. If you have a local family violence coalition, or you have a DA's office that you want to meet with, or you have other law enforcement agencies that you need to talk to, get together, crash each other's meetings, see what you can do to talk to each other, get together over breakfast. If you're in San Antonio, that means breakfast tacos. In other jurisdictions, who knows, whatever your breakfast is. But, get together and talk over food. That always seems to make it easier. One thing to remember is that protective orders are just a small piece of the puzzle, but a really, really important piece of the puzzle. There are so many different tools and practices that are in place in the criminal, legal, civil, social justice systems, and we all try to work together. But a protective order is certainly part of it, but they don't do any good if we don't know they're there. And as this presentation shows, they can actually do a lot of harm if we're not making sure that everybody is aware that they're available. If anybody has any questions, please feel free to contact me. That is my phone number, 512-936-6390. That phone actually connects directly to my cell phone, so you can always reach me because I'm really not in the office all that much. I'm on the road an awful lot. That is also my email address. And then the website there at the bottom is my page on our website for Office of Court Administration, www.texcourts.gov. You go to that, you look at programs, and you click on programs, you'll see Domestic Violence Resource Program. Click on that, and you'll be able to get a little bit more information, including other webinars that are very similar to this one, but maybe have a different focus on who the participant is. So please feel free to contact me. Thank you so much for all the work you do. I know that you are the ones that wind up getting the paperwork and the information after everybody has touched it, which means you may have a really great set of paperwork or you may have a big mess on your hands. And so I certainly want to help do whatever I can to make that process easier. So please feel free to contact me, and I really appreciate the work that you do. Thank you so much. Have a good day.